Well, good afternoon, everyone, and welcome to our latest Brexit webinar. My name is Michael Warren. I'm Brexit lead at the BIA, and I'm very pleased to welcome you to our webinar this afternoon. I'm joined today in the office by Punam Birly, who's a partner of legal services at KPMG. Welcome, Punam. Really delighted to have you with us. Steve Bates is on the other end of the line. Say hi, Steve.
Hi, Michael. Hi, Punam. Thank you for joining us.
Thanks very much. Okay, so given I'm in the office, Steve and I are going to do a bit of a double act just in terms of a quick update on the latest situation. Hopefully that'll work okay. And then we're going to have a fantastically authoritative presentation on Brexit people issues from Punam, who's done a huge amount of work and research on this and is a real expert on those issues. I know people issues is one of the issues that's come up a number of times in our questions and in the events that we've run on Brexit, so delighted to be able to welcome an expert to talk about that today. So yeah, so our agenda today is just a quick update on the latest situation, which Steve and I are going to talk you through. I'm sure you're all following the news pretty avidly yourselves. Obviously things are moving fast, so we'll try and keep pace with that with just a couple of slides up front before we turn to Punam. So let's get straight into that then. So the latest situation. Steve and I thought we'd do a quick recap actually on where we've got to in terms of October and where that takes us to today. So this slide is titled New Deal Parked as Extension to 31st of January Agreed. So Steve, why don't you take us through how you feel that September's gone so far and where we're up to now?
Yes, thanks, Michael. They say that a week is a long time in politics, and it certainly has been this week. So within the last couple of weeks, we've seen a new deal agreed by Prime Minister Johnson with the EU, the government pushing for that bill to go through Parliament to enable the UK to leave for the EU by Halloween, 31st of October. Parliament has then voted in principle to discuss the bill at a second reading, but then kiboshed the programme motion and the timetables for it to be discussed. So that meant that the Parliament delayed the bill. The Prime Minister then withdrew the withdrawal bill, and that then led to an extension being granted by the EU till January 31st, a flex extension, which means the UK could leave if the deal was done. The Prime Minister has written confirming that that's his expectation, and that then means that we just need the ratification step from the EU, which is a formality, a rubber stamp of them writing back saying that they accept the Prime Minister accepting their extension, and it means that in all eventualities, Brexit, which we had anticipated might be in a couple of days' time, is now no longer a deadline of October 31st, no ifs, no buts. It's now the 31st of January.
Yeah, so it's a flex extension, isn't it, Steve? So what does that mean?
I take it that it means if Parliament comes back, gets the deal through, then the UK could leave the EU earlier than the 31st of Jan. If the withdrawal bill is agreed. It probably makes more sense to talk about that in the context of the next slide as well, because we've obviously got other fast-moving developments in the next over the next couple of days.
Well, exactly. So we were lucky enough to have a presentation from government on this morning, weren't we? Where they went through kind of the latest situation in relation to no deal planning, which obviously is off for the 31st of October, but is going to be rebooted for 31st of January. So this slide really just sets out where government's up to and their asks of us. Do you want to quickly run through this?
Yeah. So, I mean, obviously, this means that yet again, the deadline for potential no deal has been kicked down the road again. But it's clear that for those of you who've engaged in the preparedness programme for no deal Brexit, the government will continue to operate the freight and express freight registration. The club, if you like, if you've joined, remains open. And if you want to access yourself of the ferry or the express delivery route and you've got a priority one good, that will remain open. It's unlikely that the government will change very much in terms of civil service in readiness role. And although we've seen the cancellation of some of the advertising about get ready for the 31st of October, it's likely that that will kick in the other side of Christmas. I expect to see a fairly basic letter from the government to industry very, very soon saying, you know, the deadline has moved and in slower time, perhaps over the next week or so, My expectation is that they will ask us to continue no deal planning, to continue with the readiness preparations, including stockpiling and rerouting. That if you've got any challenges that are likely to appear in the end of January, share them as soon as you can. If you've got clinical trial, you're a sponsor of a clinical trial, they still haven't completed much of their scenario planning for that, it would be useful for them to engage with that. So I think that's what we expect government to do. Again, take this on a proviso that this is sort of moved in the last day, so we're trying to give you the most accurate we can see rather than this being legal text at the moment.
Yeah, and one of the strong messages we heard this morning was that government's incredibly grateful and was very reassured by how effectively our sector, compared to some others, had planned for Brexit on a no-deal scenario, wasn't it, Steve?
Yeah, it was kind to hear that from civil servants. We have another meeting with ministers tomorrow, and we will endeavour to get more clarity on it tomorrow.
Okay, great. So just turning to the next slide. I mean, obviously that deal's on hold. We're looking at another no-deal scenario potentially at the end of January. But in the meantime, there's this big looming prospect of an election bill going through the Commons today, suggesting, proposing an election on the 12th of December, which kind of would mean a lot of this would go on hold in terms of preparations, and we'd have continuing uncertainty for a good couple of months. What's your message out to the sector as if that does in fact come about, if we do have that election, Steve? I mean, really, we're just preparing again for that new deadline of end of January. How do you see it?
Well, I think it's unlikely that the way that the government will approach that is likely to change. It's unlikely the government's approach to that will change significantly. I think we will be looking at another rerun of the similar asks and the similar processes that are available in terms of the position on ferries and on the rest of it. And of course, 31st of January, once you take away an election period, if it starts in the next couple of weeks, goes on until the middle of December, means that basically we'll have Christmas and a few weeks to go. So there won't be very much time for significant change. Of course, what we'll continue to do if there is a government reformed, we'll continue to deliver our messaging around what we hope for in terms of alignment on medicines regulation going forward. But I think this is all dependent a little bit on what happens today and whether Parliament votes to have an election this side of Christmas.
Yeah, okay, great. All right, I think I'll move on. So just a couple of slides, just recapping. I mean, people may have heard Steve say at our last webinar that this is the last one in the series. So we just thought we'd just do a quick wrap up. First of all, I just want to say on behalf of Steve and myself and everyone who's joined us on these webinars, thank you to all of you who've been regular attendees. I know a number of you dialed in to listen to us speak for quite some number of minutes over the series talking about Brexit. Hope you've enjoyed it. We've completed this phase of our program now. It's been a pretty comprehensive run through all of the issues, covering a number of events. And I just wanted to say thanks to all of those of you who've joined us, and also to our partners with One Nucleus by now, Medi Wales, by partner, and also Scottish Enterprise, who's helped us with this series of events and activities. Those webinars, in case any of you have missed any of them and would like to go back and listen to some of the detail that we've been through, cover some of the substantive issues. So there's one on continuity of supply. We did a detailed run through of the implications for regulations on medicines. We looked at trade and customs and border processes, and of course today we're looking at, thanks to Punam, we're looking at employment issues as well. So all of those webinars are available for people to go back and look at again via our YouTube channel, and of course all the information on our Brexit portal, all of the links to the no deal planning advice from government will stay live, so it will be there as a reference source for people, and we will continue to update that I think over the next few weeks if anything changes, although I think given what Governor said we don't expect much to change, certainly this side of an election. So thanks again for that. The things that we've learned from this Brexit programme over the last few weeks, well, I've been relatively new to it, so it's been an interesting learning process for me to find out what you as a sector and all of you as businesses think are the major issues and concerns. I think what we've heard at our various engagement points is that there are certainly quite a few businesses in our sector and within our membership who are still not very prepared for the concept of a no-deal exit. I think people have looked into it, but have been, making the decision for their business. It might be better off to wait and see what's happened. The issues that people have brought up, I mean, you might have seen us talk about these before. So some of the big issues have been around, so in manufacturing, things like batch testing and release, regulations, how to manage clinical trials in the no-deal scenarios, people and employment, we're going to cover, thanks to Punam, in a second, and those customs and border arrangements and how those would work. So plenty of stuff which people haven't been very sure about, we've tried to address. One of the things that I think you've certainly picked up, Steve, is that there is certainly a legitimate demand for us to continue this work in order to prepare our sector the run up to that 31st of January deadline. So I don't know whether you want to say a couple of words on that.
Thank you. Yeah, I mean, I think two things. Number one, you say today marks the close of the government-supported aspect of the BIA's work, which is aimed at the broader sector in preparing everybody for the 31st of October deadline. And of course, we've discovered that as we've got very close to it, that deadline has receded into the distance. That's the nature of the beast. Of course, what's interesting is that that's exactly what the vast majority of sector attendees expected. I think we never got beyond the lowest figure. 70% of you expected there to be a delay in Brexit during this period, and you have been proved right. So I think that goes is one of the feedbacks we can give to government about their messaging, and I think we've maintained a number of companies from being absolutely prepared to those that have not very well prepared at all. So I think we know that there's a range of company preparedness to Brexit. I hope that what this work, and I pay testament to Michael's fantastic work and people around the country on this, it now is a repository of the no deal knowledge and some of the things as to how that would work in practice, available in a curated website and series of webinars that I hope will be useful if we were to have to dig this out the other side of Christmas, or potentially even at the end of an unsuccessful negotiation at the end of next year. So although this planning is not needed for the next week, I don't believe it's redundant, and we will endeavour to curate this as a set of materials, and the knowledge that you have. I think it's unlikely that the shape of a no-deal Brexit will dramatically change in 90 days or perhaps in 12 months, and we have to be cognizant that this is aware. I think what we'll now consider is how best to engage with members in the sector, and we'll do that in slower time. Perhaps the period, if there is to be a general election as we expect, will give us the time to do that and reflect and think on this. We'll probably go away from doing weekly ones to perhaps back to monthly. But if you've got any final comments either on this series of events or what you think we should do in the future, please email us at biabrexit@bioindustry.org.
Yeah, absolutely. Thanks, Steve. Okay, so that's our upfront discussion finished with. So now I think we just thought we could maybe just have a little pause to see if anyone has any questions on any of that or would like to make any comments on where we're up to. So I suppose two big questions. Any thoughts or concerns about the current situation we find ourselves in? Or as Steve just said there, you got anything you want to feedback in terms of how you found this series of webinars or any of the events that you might have been to? Love to hear your comments on that right now, or as Steve said, fire your comments in via our dedicated email address. So let's just wait for a second, see if anyone wants to throw in a comment or two on the questions box.
Yeah, Michael, we can't really do our quiz. Do you think there's going to be deal, no deal, or delay this time? Because it's pretty obviously a delay, so we can't do our normal quiz question at this stage. So we'll have to hope for some comments from anybody who's online. I'll give them 5 more seconds, and if not, I think we should move on. Yeah,
okay. So no questions coming in, but do have a think of some as we're moving through this webinar, and we'll pick up again at the end. All right, so let's move on. And I'm going to turn to the fantastic Punam Birly. who's our very special expert guest in the BIA today, who's going to talk us through the implications of a range of Brexit scenarios on what that could mean for our people, and specifically looking at issues around immigration. So over to you, Punam. Thanks again for joining us.
Thank you very much. Really pleased to be here. So as Michael said, I'm going to talk about a range of Brexit and people issues. It's a really, really big subject. And I know there have been lots of questions. For example, what are the key people issues exactly in Brexit? People know about immigration, but are there wider issues? I've been asked several times, and I'm sure we all have discussions around what's different for people in a deal or no deal scenario. And then, of course, if we have an election, how does that impact people, the settled status scheme? Does that continue? Does it all stop? How easy or difficult will it be for UK nationals to travel for business and work across the EU after Brexit? There are also questions about the new UK immigration system, because remember, two things are happening here. One is that we've got Brexit and the implications for EU nationals and UK nationals in the EU, but we also have one of the biggest changes in the UK immigration system we've seen for more than 30, 40 years. And how easy or difficult will it be to bring EU and non-EU people into the UK for either temporary work or long-term work after Brexit? And how easy or difficult will it be for people to travel to the UK? We are going to talk about some actions and some deadlines, but I fully expect that some of those will move. At least you'll have an idea that there is a deadline, for example, for settled status applications in a deal or no deal. So what are the three key people issues in Brexit? Well, to begin with, let's just be clear on which people. Now that includes EU, EEA and Swiss nationals, UK citizens, and also dependents and family members. So all of the rights that we talk about if there is a deal will relate to wider family members, and they will apply for a lifetime. It also includes employed and self-employed people. So free movement is very often focusing on employees, but actually it's self-employed freelancers, individuals who will have perhaps employment and self-employment. All of those tend to be covered in the rules. The three key issues are immigration. Well, the first of those three key issues is immigration, the right for people to enter and live in an EU country without going through any kind of immigration application. So, for example, being able to book travel and go somewhere at short notice within the EU without immigration being a concern at all, either for admin time or cost. The second issue is social security, which is in the UK national insurance. So it's being able to access state benefits and effectively take them with you. What's the impact on that for people when they're moving around the EU and the UK? And this is also about avoiding dual contribution liabilities, so not having to pay social security taxes in all of the EU countries in which people are working. So you may find that someone has a senior sales role that involves them going across the EU, not just for business visits, but they actually spend substantive time in the EU. Will they have to pay social security in all of those countries? At the moment, they only have to pay it in the UK because we have social security coordination rules. What about healthcare insurance? So the European health insurance card can be used for emergency healthcare, and it's really valuable because it can be used for pre-existing conditions. What happens to that? The third key issue is around the mutual recognition of professional qualifications. So it's being able to have these recognized so that a person can start work without any kind of training, or if there is some extra requirement, that's minimal. And the key thing here is to remember is that that qualification must be needed for your job or service. So I've had questions from people saying, well, does that mean that as a graduate, I can't come and work easily in a particular country? It's not about that. Do you actually need that qualification in order to do your job? If you have already got that qualification, you're fine. It's whether or not you're in the process and at the point at which you're in the process that will matter. So Brexit and people. Now, in terms of there are rights that people have, and they have obligations as well. And those obligations around where they may need to pay into the system. So it's not just about their rights. Citizens' rights, which there are some citizens' rights which stay the same during the transition period, which is currently to the 31st of December 2020, and there are some that will change after Brexit. And as I said, it's a really big subject. I'm not going to go into detail, but it's important for people just to work out precisely their position and how they are impacted. And lastly, what about the future relationship between the UK and the EU? Could it be that we keep some of these key rights? So if we have a free trade agreement, could a type of free movement actually continue? So there's no free movement as we know it now, but there may be some kind of free movement. So what happens to EU, EEA Swiss nationals resident in the UK before Brexit? Well, if there's a deal, and we have a deal before the 31st, as Michael said, it could be any time before the 31st, then free movement will continue until the end of 2020. All EU nationals and family members have to apply under the new EU settlement scheme. Now, I say all because some people feel that there are exceptions and they have permanent residence already and they don't need to apply. They absolutely do need to apply, and they need to encourage their family members to as well. So if someone already has permanent residence, they will have to swap it for settled status, but there is no way around this. So those legally resident in the UK for 5 years should apply for what's known as settled status, and those who are only resident for less than 5 years apply for pre-settled status. Now, in the case of a deal, there is a deadline for applications, which is June 2021. There has been reports in the press around people being deported if they don't have settled status. Now, I expect that because the government wants to encourage people to apply, they will just extend the deadline. However, strictly speaking, if someone doesn't have an immigration status, they will not have a right to stay in the UK. Family members are also eligible to apply. And as I said earlier, all the rights will be protected for the lifetime of the individual and the family member. And the withdrawal agreement does contain a provision around the Independent Monitoring Authority, a new authority that's going to be set up to look at citizens' rights. Now, if there's no deal, let's say we leave on the 1st of February 2020, we leave without a deal, then only EU nationals resident in the UK by the 31st of January 2020 will have their rights protected. All affected will have to make an application via the EU settlement scheme. That scheme continues regardless, deal or no deal. And there will be a different deadline for applications, which will be the 31st of December 20. So until the 31st of December 20, EU passports, ID cards will be sufficient proof of right to live and work in the UK. Now, if there's no deal, there will of course be no recourse to the European institutions, European courts. And many European countries have released information on the status of UK nationals in their jurisdictions. And the key thing here is to keep up to date. So, for example, we heard that in Italy, the embassies are providing support to their people. You just have to keep linked into any particular country you're interested in and see what the changes are there. That's the only way of being absolutely sure about what to do. So what about frontier workers? Now, frontier workers are people who live in one country and work in another, and you may well have people that you know, or sales teams or other parts of the business that have people that do that. And they've never really had to think about immigration because they just come and go as they please, they book their tickets and travel and work wherever they want to. Now, if there is a deal, they can continue to work beyond 31st December 2020 if they began their employment in the UK as a frontier worker before 31st of December. There is this bridge concept within all of these citizens' rights issues, in that if you have been doing something before Brexit, generally you will be allowed to carry on doing it after Brexit. So all rights that existed before the 31st of December 2020 will continue. There will be a need to apply for a frontier permit. Now, this is all brand new stuff, and we don't have a frontier permit right now, but we're told that you have to apply for one. So again, it's a question of looking out to see what's changing on the immigration front and making sure that if you are in that position that you do get yourself a permit at the right time. Irish citizens, to be clear, do not need to apply for a frontier permit to continue coming to the UK. There is a common travel area between the UK and Ireland, and that's not going to be impacted. Now, in a no deal, if you live in one country and work in another in the EU, then you can continue and you'll need to apply for frontier worker status, and you will also need to apply under the EU settlement scheme before Brexit. if you cease to be a frontier worker. Now, there is talk of European temporary leave to remain, a new status if there is no deal, which means that because free movement continues until December 2020, people coming in after Brexit will still need to apply for some kind of leave, and this is granted for 3 years, costs nothing. You make an application, get yourself a digital number, and you then apply under the settlement scheme. So what about people arriving post-Brexit? So if they're coming to the UK post-Brexit in a deal scenario, they can continue to come, as I've just said, until the 31st of December, and they will apply under the settlement scheme. They can accumulate 5 years of continuous residence in the UK and swap their pre-settled status for settled status. Now, settled status, what that is that clearly is not nationality, and perhaps I should have made this clear at the beginning. That just means that if you have settled status, you have the right to come and go into the UK as you please, providing you don't spend too long outside of the UK. And that is a period of 5 years outside of the UK. Once you have settled status, means that you lose that status. If you have pre-settled status and you spend more than 2 years outside of the UK, you also lose that status. So what about coming to the UK post-Brexit in a no-deal scenario? You can continue until the 31st December, so it's exactly the same, but you would have to apply for European temporary leave to remain. And as I said earlier, this is free of charge and issued for 3 years. Close family members, spouses, partners, dependent children under 18 can apply as well, once the main applicant has received their European temporary leave to remain. Alternatively, there's going to be a brand new UK immigration system from 2021. At the moment, it's 2021. I don't know, things are just changing, dates are changing all the time. That may be moved, but they may have an opportunity at that stage to try and fit themselves within a particular category in the new system. So the EU settlement scheme, to recap, has been fully live since the 30th of March 2019. Every EU national has got to make an application. There are no exceptions. Even if you're married to a British citizen and you've lived in the UK for a very long time, etc., it still has to be done. Irish nationals need not make an application. There's no cost for it, and family members' applications can be linked to the main applicant's application. Now, the other change recently announced is that before this could only be done on an Android phone, and the new iPhone 8 will also allow people to complete the application. So, settled status. So EU nationals and their family members who have resided in the UK for 5 continuous years at the relevant date can apply for settled status. They must not have been absent from the UK for more than 180 days in any rolling 12-month period. And there are some exceptions. Children born to parents with settled status will automatically be British citizens, and settled status holders, as I've said, can be absent from the UK for up to 5 years before they lose this. And those who've already obtained permanent residence document under current EU law can convert this into a settled status document, subject to a few additional criminality checks. Pre-settled status, so EU nationals and their family members who have resided in the UK for less than 5 years at the relevant date must apply for pre-settled status. They can build this up for up to 5 years to gain settled status. And as I said earlier, if they're absent for more than 2 years, they can lose that status. The application process is exactly the same. Right to work checks. Now, right to work checks are checks carried out by an employer on anyone they are going to employ. So it isn't anyone who's from the EU, but just anyone, whether it's a UK national or not. Now, there's no change to current processes until the 31st of December 2020, regardless of deal or no deal. And individuals can continue to use EU passport or national identity cards or status under the settlement scheme or the European temporary leave to remain scheme to prove they can work in the UK. So employers can ask applicants to share their status under the schemes, but they can't require them to do so. And that's a question we get a lot. You know, do we have to, as employers, ask people if they've applied under the settlement scheme? The answer is no, you don't. And actually, you shouldn't, just single out EU nationals. But it may be at some point you might want to just do some internal audit review of immigration status, in which case you do that for everyone. There is a Home Office right to work checking service, which gives employers access to real-time information about migrants' rights to work. And there's also an online right to work checking service used by non-EU nationals who hold biometric residence permits and have been granted settled status or indefinite leave to remain. There's an online service which is voluntary, and employers can continue to undertake checks in the usual way. No one is being asked to carry out retrospective checks on all of their employees. However, you may want to start thinking about getting some data. I mean, what I say to clients is just say to your employees, you know, if you'd like to tell us if you made an application, go ahead, but you're not bound to do that. So UK nationals to the EU, in the case of a deal, free movement continues until the 31st December 2020. So UK nationals already in the EU before Brexit are required to register with the authorities in the country they are residing and working in. Now, I mentioned the bridge earlier. If you are already in the EU, it is likely that you will have to do less. So you may, for example, need to put an additional residence sticker in your passport compared to if you were going over to work in the EU from the UK after Brexit. UK nationals entering the EU after Brexit, let's have a look at no deal. So the EU has agreed that no visas will be needed before people travel for tourism, short visits, business visits into the Schengen area. But you have to keep track of how many of these that you do. And, you know, people that have this work pattern won't necessarily be doing that. So you cannot exceed 90 days in any rolling 180-day period. So you need to make sure your passport has at least 6 months on it as well. And there may be countries not part of Schengen but are in the EU which may require visit visas. So visas for work in the EU will be required for UK nationals. Now, people often ask the question, what's a business visit and what's real work? So a business visit could be preparatory meetings, talking about projects, but actual real work is rolling up your sleeves and getting stuck into a project. You know, is it something that a domestic worker might do? Then it's more likely to be actual work and need a work permit. Now, driving licenses, you can get an international driving license from the post office, costs about $5.50. E-HICS, an interesting one on E-HICS. It isn't that E-HICS are likely to go completely in a no deal. It may be that they're phased out. And again, you have to keep up to date. So Spain and Belgium have announced that they will allow E-HICS to be valid as long as the UK allows their citizens to have valid E-HICS or NHS treatment in this country. And just note there about health insurance, the importance of getting that as well. And I think there's been quite a lot of publicity on that, and there may be difference in roaming charges, etc. Now, the EU is going to introduce a new travel information and authorization system similar to the one in the US. It will be introduced from January 2021, so lots of immigration changes in 2021 in the EU and in the UK. It requires all third country nationals to obtain electronic permission to enter the EU, and it's going to include the UK as well because we will be a third country. The system checks security credentials and it consists of an online application. It will be processed instantly, and for those of you who have processed the US ESTA, it sounds like it's very much like that US ESTA scheme. It's valid for 3 years or on the expiry of the passport, whichever is earlier, and costs €7 at the moment. Now, I've included this slide because we do have questions from people around immigration and the process generally. So not everyone will be familiar with how you bring people into this country at the moment, people that are not from the EU. And what you have to do at the moment is to apply to the Home Office to become employer sponsor for a fee. You submit a number of documents to prove your business activity, and the Home Office then says, yes, that's fine, you can be an employer sponsor, or it says no, or it says give us a bit more information. Once you get your license, you look at the different employer-sponsored immigration categories which allow people to come into the UK. For those of you not familiar with immigration, you may have heard talk around Tier 1, Tier 2, and so on. And so this is what we talk about, which categories. And Tier 2 visas are for degree level, and those with degree level and above, skilled workers. So generally, the more that you pay someone, the easier it generally is to allow them entry into the UK, which I'm sure isn't a surprise to most of you. The business will pay a number of fees for the visa. So you as an employer, if you're sponsoring someone, you'll have application fees and skills charges, etc. And the key thing is that you need to know what the migrant is doing. And again, if you're not familiar with immigration, it might surprise you that you're seen as, it's quite an old-fashioned system in that sense, in that you need to know what they're doing and you have to tell the Home Office if they leave, you are sponsoring and you are liable. So the migrant may be able to stay permanently in the UK. Again, it depends on their category. Now, the government is looking at a new immigration system, and they may look at a sector type of sponsorship, umbrella sponsorship, so that a whole sector where you have smaller employers can get some guidance on this without having to go through all of a very long sponsorship process. And of course, they're looking at a points-based system as well. Now, on that new immigration system, it could start for EU nationals coming to the UK from the 1st of January if it's part of the deal on the future relationship. What the government's been saying is that the focus is on skills and having just one system for all categories of EU and non-EU nationals. Now, there is a proposal. I know there's a lot of talk about there no longer being this ability to recruit people at a lower skilled category. But the government is looking at proposals for introducing this ability for employers to bring in people for 12 months in any skills category. So they don't have to be earning 30,000. They can be of any level. But the key thing is it will be from countries that the Home Office considered to be safe immigration countries, countries where people are unlikely to overstay. That's under discussion. I mean, if it does come into force, let's say for 12 months in that category, there will be an insistence on the individual going back to their original home country for what's known as a cooling off period for, say, if it's 12 months in the UK, then 12 months cooling off. People have asked about minimum salary levels of 30,000. There's been a lot in the press about that. Now, that is just a suggestion. The government has been consulting widely. There are several sectors where that's very difficult to have people enter if they need 30,000. They just don't pay 30,000. There are regional differences as well. So that's all being consulted on, and we should hear about that very soon. The UK is going to be introducing a new ESTA type system as well, electronic system whereby people need permission to enter the UK, and that's a massive change. So no longer will people be able to just come to the UK and enter. They're going to have to get advance permission as well. That is a very quick run through of a number of issues. I don't know if we're taking questions here or people will write in.
They will let us know. Thank you so much, Punam. That was an incredibly comprehensive run through. So I'm really grateful. We're just going to open up questions now. So please get ready to type some in. While people are thinking about their questions, I'm going to take webinar driver privilege and ask one which has been raised with us before. So on this question of people who perhaps employees that might already have permanent residence, so indefinite leave to remain. You mentioned this point about them being able to update that to settled status. Now, should they do that? Would they want to do that? And what would the difference be?
So if someone already has permanent residence, then they have to update it to settled status.
Right.
So they have no choice but to, but it will just be an easier process for them. So they do have to apply as well.
Yeah. Very good. And the other question that has come up before, just wait to see if anyone's asked one while I'm talking.
Michael, can I come in at this point?
Yeah.
So thank you. I found it very useful. I think it's useful for companies to understand the range of change that's happening. But I find that to eat this beast, you've got to take it one bite at a time. And it seems to me, and please tell me if I've got this right or wrong, that broadly, with regard to an employer, there's nothing that is absolutely crucial that has to be done before the exit date with regard to existing staff. There is time to complete these processes before the end of next year as the first deadline. Would that be correct? There's nothing that absolutely has to be done before either before the 31st of January deadline.
Yeah, I mean, there is nothing an employer needs to do full stop. So you're absolutely right, because you can support your EU nationals, you can give them information, you can tell them that they need to apply for settled status in the case of no deal before the 31st of December 2020, in the case of a deal, by June 21. But actually, there are no obligations on the employer to do anything at all. However, I think it's in the employer's interest that their employees receive information, are not distracted, are supported, and also that their employer understands that as EU nationals, a lot of this is really, really unsettling. It's very emotional, it's very difficult for them. They may be making some real choices. So engaging with employees, is purely voluntary, but where I've seen it happen, it is really valued.
So I think from my perspective, I'm taking the perspective of a small business who've got to do things in priority order. And if they're waking up to Brexit, my view is, yes, you're going to have staff that are concerned and you're going to need to reassure the staff, but actually the staff don't absolutely legally have to do anything. Nothing changes for them on the day of Brexit if they are already here and already in employment. There will be some stuff that needs to be gone through. But I'm also keen to understand from you as to whether all of the elements that you've laid out here are in statute, are through the House of Commons, and are the legal position.
Okay, so let me just come back to this. So employers are not bound to do anything for their employees. The only situation is where if you are sending your employees over to work in the EU, then you need to make sure they're compliant. So in whatever situation, if they need a work permit, then you're obliged to make them compliant, you support them. If you suggest to one of your employees that they might want to go on secondment for 3 years, 4 years, and that impacts their ability to get settled status, and you may want to do that. So does that answered your first question, hopefully. The second point is how much of this is actual law at the moment. So at the moment, free movement continues because we don't have the legislation in place right now which has ended free movement. All of the rules around social security are in the bill, but they're not law yet. Settled status is a matter of government policy. So some people have argued this is just government policy, but it's being required. The immigration rules the immigration rules change all the time. They're a slightly odd type of secondary legislation. They're not quite secondary legislation, but they are the source of all of those rules. They set out the requirement for EU nationals to apply for settled status. But technically, at the moment, as members of the EU and citizens of the EU, arguably they don't have to do it. Where they will have to do it is where we've left the EU and the law says actually now if you don't have a status under UK law, this is why it's a voluntary scheme, then if you don't have status, then actually you have no right to be here and could be asked to leave.
But the reason I'm thinking about this is that there is a chance that chunks of this, as we've seen with other aspects to do with Brexit, stand a chance of changing over the coming weeks, months and years. And this is the difficulty, I think, for businesses, that we hope for certainty, but actually there is a degree of nuance that could change as a result of parliamentary amendment, a change in government, a change in ministerial direction, or is this set in stone?
Yeah, and the answer is that, well, for the settled status scheme, let's just say that we revoke Article 50 and we decide that's it, we're going to stay in the EU. I think the settled status scheme, for those people that have already had it, we may end up asking others to actually apply for the same kind of status in order to avoid these two groups of people. Or we could just have this system, it was a legacy status and it means nothing now. But the key thing is that the immigration system is going through massive change, and this is about making things uniform. So it could be that you have that status and in law it doesn't differ at all to someone who doesn't have it. But I would be surprised if we gave up on this brand new system, which is going to be more digital. Everyone has a digital identity, a digital status, etc. So the settled status scheme in some form is likely to continue, but the only way none of this will happen is if we absolutely decide not to leave the EU.
Great. Okay. Any more from you, Steve?
No, I think this is really helpful. But I mean, as I say, I think for us picking our way through this, because obviously as an advocacy organisation, we are seeking to influence the new system with government to make it straightforward and easy for members and businesses to recruit the people that they need, maintain people that they need, make it less onerous for businesses. But we are doing that in the midst of the difficulty that you see from the Home Office and changes and whims in the newspapers from ministers as to their approach. I think I agree that it seems that the framework on which this will be based is fairly clear, because in a sense the Home Office architecture has to be built for the new era. But I just put a small flag for companies that we are likely to see movement in this, as we have already seen in previous months, and a continually evolving system.
Okay, great. Thanks, Steve. No more questions in from participants, but so I'll just say thank you very much, Punam. That was an incredibly authoritative run through. You're right to say there was lots of detail, but I personally found it, and I'm sure our listeners did too, incredibly useful. So thank you so much for your time today. And all that remains is for us to say thank you for everyone for joining us. Just to repeat what Steve said earlier, we'd love to hear your feedback on this series of webinars, so please do get in touch, biabrexit@bioindustry.org. We'll get an email through to us. Thanks for listening. We look forward to joining you again sometime very soon. Keep your eyes on our website for details of our next events and webinars. Thanks very much, everyone. Cheerio. Steve, do you want to say goodbye to everyone?
No, thank you very much, and goodbye.